Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. Once again, my co-host, Jesse Barrientes. Jesse, how you doing, sir?
I'm doing great, Dave. How about yourself?
Hey, very well. Good to see you.
You too. Great evening.
So, we need to talk about a topic that unfortunately is still permeating this country, and that's debt.
Yep.
Whether it's a credit card bill, a medical bill, someone who lost their house in foreclosure, someone who got into a car that they couldn't afford, or just lost their job or divorce or illness. There's insurmountable debt that some people are feeling in this country, and thankfully, there's a federal law that protects those types of people.
Well, how about those people, Dave, that just go over their limit, that they don't know how to really manage their money, and realistically, they're just they're kind of just spendthrifts, and then they have an opportunity to cheat all of the creditors where they got the stuff, and now it's because there's two sides to every story here.
Yes.
And I mean, there's a lot of legitimate reasons to help the people get off of their feet or back onto their feet after a traumatic experience. But when people come in the first time, and then the second time, and the third time, and they're doing a bankruptcy, and they're discharging all these creditors, but yet, hey, look, they got the services, they got the appliances, they got everything else, and it's just like kind of a way of life for some people.
Well, it could be a way of life for some people, but I think the creditors are getting smarter, and they're thinking about how they're going to lend on a second case after someone's filed. They're going to do their due diligence.
But you have the other opposite coin, that too. I mean, there are some creditors that, for lack of a better word, maybe predatory creditors, where they're trying to entice people and get them to spend those things. So,
Right.
hey, it depends on where you go on the scale.
That's true, but the people are hurting. The banks are not hurting. The credit card companies are making incredible profits. The banks are lending at a certain interest rate and paying interest at almost next to nothing.
That's true.
So the banks are really winning out. But for those who are struggling, it's good to know that the Congress put this into the Constitution right from the beginning, the framers of the Constitution. They put in the bankruptcy article, which said that Congress can make laws pursuant to bankruptcy. And one of those is Chapter 7, which is a fresh start. So what do you think about Chapter 7, fresh start, for someone who just got over their head or something happened that they just couldn't control?
Well, again, it's good to have a mechanism for people to get back on their feet. There's no, they used to have debtor's prison, and you'd lose all of your stuff. You would be taken actually into servitude to pay that back, and that's obviously a long time ago. Ones have progressed, but to be able to get out of with a fresh start completely, not only financially, but also, and you've done this for a long time, you could see people emotionally as well.
Yeah. What does it take to get out of debt? What are some of the requirements that someone has to do before a case can be officially filed with the clerk of the U.S. Bankruptcy Court?
Well, before they can file for that Chapter 7 or Chapter 13, we might talk a little bit about both, they have to take their class, which is a precursor to their debt management class, which is a precursor to being able to file. I know on many occasions when they passed that law, it's been so long now, I don't know how many years have gotten behind that, but when even if it's by a day or an hour that they filed it and then completed the class, and they did the filing before the completion, then what's going to happen with that, Dave?
Yeah, the case is going to get dismissed, or it's going to be void from the beginning, because it really is a prerequisite. You must complete the credit counseling session before a case can be filed. There are some exceptions if the class is unavailable, if someone's out in a rural area or otherwise incapacitated, but for the most part, 99.9% of the time, you need to take that credit counseling session, which just takes an hour or an hour and a half, and it costs anywhere from $10 to $15. It's not a big expense, but it is a time commitment before a case can be filed officially with the court to get the relief.
You might as well do that first.
It's just another class that individuals have to go through that the government has mandated. It's just one of those things. The hope was that people would take the class and then not need to file, or they'd come up with some kind of debt repayment plan outside of bankruptcy. That was the congressional hope. But in reality, people are taking the class because the attorney is saying, this is where you need to go to take the class so I can help you file.
So a hoop to jump through. So what do you think,
Absolutely.
Dave? Do you think that that the class, with that hope of being able to restructure things to pay it without having to file, was done by maybe the lobby from the creditors?
Absolutely, 100%
Yes?
credit card lobby. Yes, because they were hoping, first of all, if you put an impediment in front of somebody, it would prevent some people from being able to file. And second, they thought if some people took the class, they would think about a repayment plan as opposed to filing. But in reality, the class doesn't knock bankruptcy. It doesn't really encourage people not to file. It's really just an exercise where you receive information, and then you provide some information regarding your income and expenses, and then the counselor gives you some advice. But again, most of the people are going to the class because they were told they had to do it by their attorney. They want to file bankruptcy. So it is just something they have to check off the list and provide to their attorney before filing.
Well, Dave, if you have more debt than you have income, and I've told a lot of people that when we go through the huge intake form and look at all the financial picture of their situation, that I always tell them, you don't need me to tell you that you're spending more than you're making. Now, it could be for a lot of different reasons. Could be that, hey, look, they're supporting 5 or 6 kids, or could be that they had some medical expenses or medical bills. Could be that the car went out, or the furnace, or anything like that. Sort of like the state budget's crisis, right? You can't spend billions more than you're taking in.
Not even the state, the federal
Right.
too.
Right.
It's the same thing. It's just a microcosm. People are falling into the same trap. The difference is the government is knowingly spending more than the budget is allowing. Individuals sometimes get into a problem where they have a medical condition or they have a job loss and they have to make their rent. They have to make their car payment.
They have to pay for the prescriptions.
They do, yes. They have to feed their children. So in some cases, it's not through necessarily overspending. It's just something happens, life happens, and all of a sudden they didn't plan that well. They didn't have an emergency fund. They didn't have a backup.
And
they don't have a family member who can just jump in, or a rich uncle and say, hey, I'll make everything good. I'll make your credit card payments for the next 6 months while you're looking for a good job.
And it takes a long time because a lot of times folks rob Peter to pay Paul. They'll play one credit card against the other, and
Yeah.
that's a losing game, isn't it, Dave?
It is, but the credit card companies actually encourage that. They send people letters and say, transfer to us. We have a lower interest rate. We have a better benefit package. We'll give you more miles.
We'll give you a gift card for $50.
Yeah, so there's an incentive, there's an enticement to get people to play that credit card shuffle back and forth. And some people do it out of necessity. They have to get into a lower interest rate to be able to survive. And
To
they
be able
do
to
jump.
make the minimum payment that they're never going to surmount.
Right. But most debtors that I see are not that savvy in terms of jumping credit cards. They're more looking for a way out. And they have reached out to the credit card companies in many cases, and they don't get any relief from them. They don't get a deal. They don't get a break. The credit card companies are very reluctant to open up that door because the fear is that word of mouth will spread and more people will default on purpose so that they can reduce their outstanding balance. So the credit card companies stay pretty tight, and they stay to the letter on the debt owed for the most
Sort
part.
of like the foreclosures. But wait a minute. Hey, there's another avenue available to folks. We have these wonderful debt consolidation companies that spring up everywhere.
Well, good luck to you if you're going to do that.
Why is that, Dave?
Well-
What is? Why don't you speak to what a credit consolidation outfit or company? What do they say they can do?
Well, what they're trying to do is they're trying to get all of the debtors' creditors in one place, and then they want to cut deals with all those creditors to get them to accept less than what's owed. The problem is, not every creditor is going to go for it, and if a creditor doesn't want to play ball, they can go ahead and sue the debtor, garnish wages, and basically snuff out any kind of effort to repay. But secondly, you're going to pay that debt consolidation company a fee for that service, and they're basically paid by the credit card companies. So there's a incentive to help the debtor, but in reality, it's usually not successful. And a lot of debtors come to me after they've tried credit counseling, and they let me know that they've just wasted a bunch of time and money.
So it's a plan without any teeth, really.
Right, it doesn't have any strength. The creditors have to agree to it, and certain creditors will, certain creditors won't. It depends on a lot of different factors. How long the debt's been in default, whether the debtor has the ability to pay. They might want to see financials. So most people who are struggling financially are going to opt for the fresh start under Chapter 7 bankruptcy, as opposed to grinding it out for a longer period of time, just trying to stay afloat in a debt consolidation program.
Well, let's start. Before I'm going to ask you this question in terms of income levels, and believe me, I've seen all different kind of income levels in dire straits when you would think that that you shouldn't have to be. So what if I want to get a fresh start? Is there a certain amount of money that I can make, or I'm not able to make, or does something exclude me?
Well, there's a financial calculation based upon the median income for the state, for the household size, for the family size. So if you're a family of 2, you're going to make a certain amount of money and be able to qualify. If you're a family of 4, you can make more because obviously you have more expenses for that family. There's more people to feed, more expenses.
Well, what if I mean, my wife is working, but I really don't want to include her income because really, I'm just going to do it. Her credit's pretty good. We might need it for something a little bit later, to be able to maybe, grab a bigger house or to have her refi in the house. So, she's not. It's just going to be me. So, so we can use my income and both of our expenses, right?
Well, marriage is a partnership, so it's for better or worse. So if your spouse is a breadwinner and you are not, you may not be able to file a bankruptcy because they're going to factor in your spouse's income to determine your family size budget.
But wait a minute, that's got nothing to do. Hey, my creditors have to do with me. It's got nothing to do with my spouse. So why would that be a requirement? What was the thinking behind that?
Well, again, in a marriage, in a household, it's everyone together. So your spouse would have to take care of your bills is what they're saying. They don't want to let you out of the debt if your spouse has the ability to help you. So it's a total family budget. So it's a total family income minus the total family expenses. So you've drug your wife into it, like it or not, by marrying her.
Okay, well, couldn't it be said that she drug her husband into it by marrying him?
Oh,
You
sure.
could say that too.
Sure.
Okay, very good. All right, so all right, so let's suppose then that, we take her income into account and my income, and I don't know, let's say maybe, with the combined income, we're at like $65,000.
Well, you're probably over the median, which means you're over what an average typical household of 2 in your area makes.
What would be the average typical median for a household of 2?
Well, I'm not sure what the figures are. They change all the time, but it's statistical based on the census data.
But it's certainly not $65,000.
No, it's going to be less.
So if I'm above that median, so I can't do a Chapter 7?
Well, you still may be able to file, but now you have to submit to a means test, which is a mathematical formula in much greater detail to determine whether or not you have the ability to repay your creditors a small amount under a Chapter 13 reorganization. So basically, the means test means, do you have the means to repay? If you don't have the means to repay, you're entitled to that fresh start under Chapter 7. If you do have the ability, then you have to repay. So some people are just overspending in terms of housing and food and transportation above and beyond the IRS allowances. Those people don't qualify because they're spending too much, and the IRS allowances is all you can get under the means test.
So just to make sure that the viewers know, okay, we're talking about Chapter 7 and Chapter 13. Chapter 7 is a fresh start. Chapter 13 is like a consolidation plan, right?
With strength.
With strength, where you pay back as little, you pay back your secured creditors 100%, or your unsecured as little as 10% all the way and up to 100%.
Yeah.
Okay.
It's going to depend upon a number of factors. Your income, your expenses,
right,
and the types and the amount of debt that you have. So if you only have the ability to pay the equivalent of 10% over 3 years or 5 years, that's all that you would be required to do.
For my unsecured creditors.
If on the other hand, if your budget shows that you have the ability to pay back 100% over 5 years, that's typically what you'd be required to repay.
But I wouldn't have the interest and I wouldn't have the penalties?
That's right. Interest would stop, late fees would stop, creditors would not be able to sue you while this repayment plan is in process. In fact, they couldn't even call you. It would be a violation of the bankruptcy law known as the automatic stay, which is the big stop sign that goes out to all creditors saying, do not contact or try to collect on these particular debts because the debtor has filed for relief under Title 11 of the United States Code.
Plus, they're represented by an attorney and they can't contact somebody else if it's an attorney on the other side.
That's true. They would have to send all correspondence through the attorney.
So let's go back. So, all right, so we're talking about, I'm trying to get this, I would like to try to maybe get a fresh start here. So, all right, we're over the median income and we do the means test. So let's just suppose that, because we have, we get a car payment and we have a mortgage as well. Let's suppose then that I have those couple things, and if I pass the means test, which means I can't afford to pay anything back, then I could still do a Chapter 7?
You could still do a Chapter 7 if you pass the means test, and you can probably keep your house and car provided you continue to make those payments, provided there's not significant equity in those items.
I was going to ask you about the house because a lot of people wonder, hey, listen, how can I do a bankruptcy when I have this house and I've got, oh, I don't know, if you do the math, if you're not underwater, I mean, I don't know, maybe I've got $20,000 worth of equity in it, maybe.
Well, an individual in Illinois can protect up to $15,000 worth of equity in a property.
Well, it belongs to both of us, right?
It does. So your wife's equity would be a factor as well.
So we could have up to 30.
Yeah, and you could technically have even more than that because a trustee would have to figure what it would take to sell that property, 5% to a realtor, title insurance, cost of sale. So really you can have more than that, but you don't want to get to a point where you're enticing the trustee to dig deeper and try and sell it. You want to make sure that you're under the certain exemption amount just so that you're clean, you're perfect.
Okay, what about my car? I'm going to need a car, and my wife is going to need her car to get to work.
Yeah, well, most people don't have equity in their car when they're going through a bankruptcy, but sometimes they do, but most times they don't. And Illinois allows you to keep $2,400 of equity in one motor vehicle, and then you have a $4,000 miscellaneous wild card exemption that you could sprinkle on top of that $2,400. So you can have a little bit of equity in a car and keep it as long as you continue to make your payment in Chapter 7 bankruptcy.
Well, what if I'm upside down on my car?
Well, then you have an option. You can give the car back and get out of the debt.
But I'm not going to be able, after I do a bankruptcy, to purchase another car.
Oh, yes, you will. There are plenty of places that specialize in auto financing after a bankruptcy, even during a bankruptcy.
But am I going to get taken advantage of because I've got, the specter of bankruptcy over my head here?
No, you're going to pay a little bit higher interest rate, but you're not going to be taken advantage of. You're going to get a decent car at a decent monthly payment at a decent interest rate. It's not going to be as great as someone who never filed for bankruptcy, but it's certainly not going to be through the roof either. There are companies that want to cater to that group, and if they can keep the deal affordable, they've got pretty good chance of repayment success.
Well, what about, we talked about the house here. So what if we decide to purchase another house? I mean, I'm not going to be able to do that with bankruptcy on my record.
Well, you already have a house, correct?
Right. We're going to, maybe we want to downsize, or we want to, move to a different neighborhood, one that's maybe more affordable for us.
You should do two things. One, you should work on your credit after bankruptcy, make sure there's no negative credit. And two, wait about 3 years before you apply for a decent mortgage and have a decent down payment at that point. If you can do those 2 or 3 things, you'll be in a greater position to get another house, especially a smaller house. If you're looking to downsize, you'll have a different price point. But there definitely is life after bankruptcy. People get cars, people get houses, they rebuild. Unfortunately, they get offers for credit again really fast, and some people fall into the trap of getting credit again and just making the minimum payment and getting behind. But there is life after bankruptcy. It's not a death trap.
How long is that going to be on my record?
It's going to physically say on the credit report that you filed a bankruptcy for 10 years. However, before you get alarmed by that, you get offers for
10
credit
years? You were
immediately.
talking the last show about 6 months being a long time. Oh my gosh, 10 years? Are you kidding me?
Well, the difference is what goes on your credit report and what reality is are two different things. It doesn't matter if it's on your credit report for 10 years if you're getting credit immediately. If you're getting a car, if you're getting a house, if you're getting credit cards. You can always get a secured credit card. That's where you put money in a bank, and that is your credit.
It's not really secured. It's really just a debit card is what that sounds like to me.
No, it's a secured credit card,
Okay.
which starts to report favorably to the credit bureau. So don't worry about the 10-year time frame. That's just something that the credit bureaus report. That's not how you're going to be affected for the next 10 years. It doesn't work that way.
Well, okay, so that's 10 years. That's a long time. Gee, what happens if later on down, God forbid, I should have a medical issue or something like that, and I might need to try to do a fresh start again? Because medical insurance, Dave, is pretty expensive. And even though there's a penalty if I don't have it, I mean, I can't pay everything.
Well, look, if you have a good attorney going through the bankruptcy process, you're going to be advised on certain things to do after filing. Whatever caused you to fall into debt in the first place, you do want to take corrective action. If you didn't have medical insurance before filing, you better get it now, okay? If you didn't have the ability to make your car payment, you better get into a lesser car that you can afford. If your credit cards is what got you into trouble with overspending, maybe you just couldn't say no to people for gifts and holidays and things like that, or spouse, you have to change that conduct. Otherwise, you will be back in that same position, and you can't do a Chapter 7 again for 8 years. So the creditors are going to have an opportunity to sue you and collect.
Well, that's
And that's fair, right?
Well, hey, if you owe the money, I mean, but 8 years is an awfully, awfully long time, and it's easier to say than to do something. So to say that, okay, well, you better do this, you better do that. Well, that's why I got in the problem in the first place. I mean, it's probably not likely for it to happen, is it?
Well, some people do have to wait out the 8 years, and they do have to file again.
Okay.
It's unfortunate, but it does happen.
Well, so I can't. There's nothing. I'm just out of luck, stuck there. If I get into a jam again, I mean, obviously I can't do a Chapter 7. Is there any other hope for me, Dave?
You could propose a repayment plan under Chapter 13.
So I could do a Chapter 13 after I've done a Chapter 7.
You could. You have to wait 4 years to get an actual discharge in a Chapter 13. A discharge could be where you're paying less than 100% back, or if you're not interested in a discharge, you just want a payment plan, you want to stop the interest in the collection, then you could file anytime, immediately after Chapter 7. You're just going to have to pay it back in full over 3 to 5 years.
So if I file, or I'm able to file a Chapter 13, which is a partial repayment consolidation, within 2 years of filing a Chapter 7, I've got to pay all my creditors back 100%?
All of those that file claims,
Well,
but you're not going to get a discharge. That's important. You're not going to be able to pay less than 100% back and wipe out the remainder. You can do a 10% plan,
Right?
but keep in mind that other 90% is going to be due and owing after your 3 to 5 year term.
So what's the point of me doing that?
Well, you hold the creditors off, get a little breathing room, take a breath. Maybe in 3 to 5 years, your financial situation turns around. Maybe you get that promotion, that job that you were looking for. Maybe you inherit some money. Maybe you come into wealth. Maybe that lottery ticket that put you into debt actually produces a winner.
Yeah, you never can tell.
You just never know.
So what if it's after 2 years?
Oh, if it's after 4 years, you can then do a 10% plan.
Okay, so I'm stuck on 2 years. So if it's less than 4 years, then it's
You don't get a discharge.
I don't get a discharge,
Yeah.
and I'm going to owe the rest that's due.
Right.
Even though the plan might be a 10% plan.
Right.
So if it's 4 years and a day,
You could do a Chapter 13 and get a discharge, which means you can effectively pay back less than what's owed and wipe out the remainder. But let's not talk negative here. If someone does a Chapter 7, I want to see them get a fresh start, not fall back into debt. And most cases, people do not fall back into debt that quickly that the scenario that you're painting, 2 years, 4 years. It just doesn't happen that often.
well, I don't know. There's a lot of the economy, what it is, and the things that are happening, and all kinds of horrible things. A lot of doom and gloom, But let's talk about the process here. What from the time I come into your office and retain your services to the time, is there like a timeline of things that happen?
Chapter 7 is the simplest and the quickest case.
Okay.
Start
let's
to
do
finish,
Chapter 7.
110 days typically, from filing until discharge. And there's one meeting that you have to go to within approximately 4 to 6 weeks after filing.
What kind of a meeting is that?
Well, it's a meeting of creditors. You have to appear before a Chapter 7 trustee who is going to examine you under oath. So you have to raise that right hand and testify that all the information is true. And that's so that they can make sure that you don't lie about having certain assets. They want to put that pressure on you of the oath, which is a good thing. The trustee will most likely find that there are no assets that he or she can take and sell and pay to creditors, because again, you get that protection of Illinois law, the exemptions, $30,000 in real estate for a joint
Right.
couple, $4,800 in vehicles for a joint couple, $8,000 in miscellaneous wild card exemption for a joint couple. So in most Chapter 7 cases, the attorney is going to make sure that you're going to come out of it unscathed. If not, they'll advise you that there's a risk, and if there's a significant risk, that attorney will probably say Chapter 7 is not the way to go. Consider a Chapter 13 or no case at all.
And what's the probable cost? Is there a filing fee?
Yeah, the filing fees are pretty high, unfortunately. For people who don't have significant income and who are struggling financially, at the time of this taping, it's $335 to file a Chapter 7.
How much for the class?
The class is $10 or $15.
Okay.
The bulk of the money is going to the federal government. And for a Chapter 13, it's $310. So you're looking at a lot of money just to get a case filed. We haven't even talked about the attorney's fees. And those could range anywhere from $500 to $1,000 up to $4,000 for a Chapter 13 over time.
Well, it comes out of the plan as you're going along.
Yes, in a Chapter 13, the attorney is typically paid through the plan. Some attorneys can ask for their money up front, but most of the attorneys with a heart and who care about their clients are going to give them an opportunity to repay as they're going through the process, a little bit per month over a 3 to 5 year period, which is about $50 or $60 a month if you calculate it over the duration of a plan. Not too bad.
That sounds kind of rough. Well, what happens if we start? Well, I mean, hey, look, you know, I can't even make the car pay. I don't even have insurance, right? So how am I going to be able to pay that? And to pay you at the same time. I mean, you know what? Maybe I could try to do it myself. How about that?
Oh, good luck to you.
Oh, why do you say that?
Have fun at that.
How so?
Wow, are you an attorney?
I am today.
I don't think you want to try and negotiate in federal court if you're not an attorney. It used to be something you can do 20 years ago. People could buy forms at an office supply company.
It's not practical, essentially, is what it is.
It's
and it's
not.
not advisable. What's the old saying? An attorney who represents himself has a what?
A fool for a client.
That's right.
Yeah.
Let me ask you something real quick. I don't think we have a whole lot of time left, but just this real quick question, because I'm sure a lot of people fall or might fall into that category. We're doing up a Chapter 7 here, and what happens if, okay, hey, we're in that Chapter 7, and during that time, I get that promotion, or I get that lottery ticket. That's not for a lot, but and that kind of what happens then? Can I? But not enough to pay for everything. Can I convert it? Can I dismiss it and redo it, or do a Chapter 13 after I do? What can I do?
Well, good news for you. The filing date is the controlling date. It's a snapshot in time. So if you file on July 1st and you buy that lottery ticket on July 2nd, that's actually a post-petition after filing event. So you'd be able to keep that. Same thing with a promotion, except if that new job is going to be enough to pay a portion back to your creditors, a savvy trustee might say, you know what, you're not entitled to a 7. You're not bringing this case in good faith. You have the ability to repay now.
Well, I mean, it wasn't good faith before when I brought it. I just, hey, what? I should complain that my boss gave me a raise.
Well, a raise probably won't make a big difference.
Oh, well, promotion. Promotion goes with that. But so what you're saying is, which is interesting, is that so if I got the lottery ticket and it's for $1 million, well, of course, state can't pay it now anyway. But if I got the lottery ticket and after I filed,
you're good.
They're not going to include that?
No, because that snapshot again. They can't look forward and see what happens.
What if I get an
asset-wise.
inheritance after the filing?
That's different. Inheritance within 6 months of filing can be taken and it must be reported.
But not the
That's
lottery.
a big deal. No, not the lottery.
Huh.
That's just happenstance, chance.
Okay.
It's like somebody gifting you something, not inheritance, but just a gift. Someone could do that for you and get you back on your feet or buy you a house or a car.
And they don't take that into consideration either? If somebody
No,
gifted
because it's
it?
not bad faith.
Okay.
It's just good fortune for you.
All right. Well, that's a lot of information, Dave. That sounds pretty.
So let's recap.
good.
We've got the Chapter 7, which is the fresh start.
Right.
110 days start to finish. Gets rid of just about everything except student loans, recent taxes, parking tickets, child support, and debts incurred by fraud. Chapter 13 is a consolidation, okay? And that's a repayment plan. Great seeing you, Jesse.
You too, Dave.
So we
It's been
got
a pleasure.
7 and 13.
Yeah,
We'll see you next
good one.
time
Very
on
nice.
Legal Action.
Yeah.
Take care. Bye-bye.